Thank you, Your Honor. May it please the court, counsel, Harris, ladies and gentlemen of the jury. This is now my opportunity to give you my opening statement on what I believe the evidence in this case will be. What I tell you is, just as Mr. Tyler tells you, it's not evidence. You haven't heard any evidence yet. You won't until people get in that chair and testify under oath. In this particular case, you're going to hear two people testify by deposition. They won't be here live. The lawyers will be playing roles. One will be the witness, the lawyer will ask the questions, and the deposition will ask the questions. So that's how the testimony will come in. One is from a physical therapist by the name of Sashi Bombay, and the other doctor by the name of Dr. Kennedy, who is going to do certain problem in the case. I will tell you what I think the evidence in this case is going to be. Mr. Tyler and I have lived in the case for quite a while. The incident happened on October 1st, 2009. My client was at St. Mary's physical therapy facility, and she was walking with us, and she was walking around the track, and when she got almost to the end of the track, this got caught in a rug that was on the track, and she fell down and broke her hip, and had a serious, complicated fracture that required surgery, the installation of a large plate with 8 long screws. I have an x-ray that you can see it all, including a large screw that goes into her hip, basically it's a hip fracture. So people call it the fluid fracture, others call it hip fracture. Karada Harris was dealt a bad hand before this happened. 2 years before she fell, she was diagnosed with cancer. And the evidence will show that the cancer was a tumor that was on her sacrum and pelvis. And M.D. Anderson, the world around the facility in Houston, Texas, treated her and performed a radical surgery on it and removed the cancer along with part of her pelvis and the sciatic nerve in her leg, which basically meant that she had no nerve for the leg, which means you can't control your foot, you can't really control the lock. That saved her life. She's cancer-free. She's gone through the MRI since, and it hasn't come back. So she's alive. But the surgery left her like a baby, a child. She couldn't go to the bathroom. Couldn't walk. So in October 14th, 2008, she started physical therapy at St. Mary's Physical Therapy Center in Holbrook to learn to become independent, to learn how to walk. She started with a wheelchair and progressed to a walker. And after 9 months of treatments, a walker, a wheelchair, eventually graduated to a cane. And by August of 2009, she was able to independently begin to walk. And around August of 2009, she starts walking around on the track. There's a track in the physical therapy department. In the middle of the track is an exercise. The track is on the floor. It's not tile. It's not carpet for sure. It's hard to describe. It's a walking track. And she would walk around this track, and she would do 2 laps. The time she started, and other exercises, the physical therapist, and the Kimberly, justified that. And then she would finish the session with another doctor. Amber was often late for physical therapy treatments, told Rhonda that when you get here, if I'm not here, go ahead and start to walk without me. So on October 1st, that's exactly what she did. We'll go through the records. It will show the progression that she made. Progression said to wheelchair, to walker, long time on a walker, and it finally became, and how much better she was getting. Every single time she walked, it was a change. Her goal was to be able to walk down the aisle at her daughter's wedding by herself. So on October 1st, she goes to physical therapy. Amber's not there. She starts to walk around the track. When we walk into the gymnasium, it's called, there are chairs that are on this side, and then there's this oval. She starts to walk around the track like this, like this, like this, and she goes back to almost the beginning. And it's almost at the beginning where there's carpeting on the floor of the track. And it's the kind of carpeting that one would expect at the threshold of a business or even a hospital or physical therapy, because in fact, this is physical therapy department and that kind of carpeting at the threshold of the business. When you walk in from the outside in this physical therapy facility, you are double doors. You walk in from the outside doors, there's carpeting down on the ground. Then you walk through another set of doors, there's carpeting on the other side, and now you're inside the facility itself, not in the gymnasium. And that's the kind of thing that's there for weather, for snow, wet shoes, keep the floor from being slippery so people don't slip and fall. But in this particular case, this carpeting was on a track inside, not at the threshold, not when you walk in on a clear October 1st day. There's absolutely no reason to put it on a place where people are walking with canes without nerves, without control over how their feet work. It is a change in surface for the entire walking day. As she walked back in front of it, as she started, as she put her cane out, started to slip, caused her to fall. As she fell on the right side, fell on the right hip. EMTs came to the scene. She reported to the EMTs. The cane was caught on the run. She reported to Andrew Kimball that she tripped. She was found on the run. She reported to two other people that she tripped on the run. So there's, I believe in this case, there's no issue. But this lady fell on a run that had no administration. And as a result of this fall and this fracture, she was seen in an emergency room at the same hospital. And the next day, after one used one surgery, put in a plate, and she went through probably 9 or 10 months of follow-up with Dr. Andrews. The damages in the case, I think the others will show that $65,000 large plate screws, iron screws, pain because of the plate located in other places. The damages in this case really are, I believe, to show motion because of the fact that dealing with somebody learning to walk again and got their point and she's just up there and because of this injury, this fracture, it was all for naught. She's got to spread right. The evidence is being tested. The her is that she doesn't really need to walk. At the conclusion of the case, I would make a closing statement. I would make a closing statement. The judge is going to read the instructions on the law in this case. And I will submit to you that this is a bit of an unusual case because we have kind of two legal theories for it. One is medical malpractice. That there was malpractice on the part of the physical therapy people who say because the physical therapist who testified in this case will all say that she should not have done her testimony will be for that time. So that's not a practice. But the other legal theory in this case is premises liability. And that is that there was a carpet blocked. There's no reason. There's no reason. It made no sense for him to do that. At the end of the case, I'll tell you the legal theories. Which way I think we should go based on the evidence. And then we will deliberate and decide and discuss it over. And we'll come back and really look at the evidence. Thank you.
Tyler?
We have, Your Honor, defendants
Okay. Sorry, sir. Okay, Paul, just hit the defendant video.
It's the very first one.
Okay. Now do I hit the seal too, or?
That's the case.
Okay. It's on. You're set.
Thank you, to the police and court. Mr. Sherman, Ms. Harris, counsel, ladies and gentlemen of the jury. Suffice it to say, the hospital has a very different take on this. And we think it's going to come down to two things. What actually caused Mrs. Harris to fall? Why she was out there in the first place by herself walking laps on the track. What the evidence is going to show is that the hospital did nothing wrong that caused or contributed to her fall. There was nothing unsafe about its premises. There was nothing unsafe about that drug there. There was nothing inappropriate in the physical therapy services that she got. In fact, we think the evidence is going to show Mrs. Harris did not trip on that drug at all. In fact, she fell because while she was out there walking around and she wasn't supposed to be, her right leg became fatigued and it gave out. What you're going to hear in this case in the next couple of days is a very sad story about a nice lady who unnecessarily put herself at risk of fall because of an underlying medical condition she had. And that risk materialized and she fell over her bed. Everybody's pretty much in agreement. She had a seriously weak right leg and a flaccid right foot on her cancer surgery. She couldn't hold her foot and sometimes drag it to the ground. She'd taken therapy for almost a year at the time this accident happened. And she was just at the point where she could walk with a cane. She was just now contemplating a few steps without an assistive device. But her therapists were planning her discharge from therapy because she had plateaued in her recovery. She wasn't going to get into bed. And that was a problem. Ms. Harris, counsel has alluded, wanted to be able to walk down the aisle when her daughter's wedding without an assistive device. And now the therapist was telling her, you're not going to do this much longer. So she made an imprudent decision to go out on that track by herself and walk laps. She wasn't supposed to. She had a bad day and that diseased leg gave out, failed underneath her, and she collapsed. Now I want to give you a preview of some of the background evidence you're going to hear about this situation. In 1999, Ms. Harris, her physicians found a bony abnormality on the right side of her pelvis while she was getting some other medical care. They watched it for years by way of serial CT scans and serial MRIs, and it appeared to be stable for the most part. And then in 2007, she began to have right-side pain, and that pain started to get worse. In 2008, she had a biopsy of her right sacroiliac joint, and it showed had a chondrosarcoma on her pelvis. That's just a fancy medical name for a cancerous lesion in the cartilage. She went down to MD Anderson Medical Center in Texas, which is world-renowned. They evaluated her, and then in August of 2008, she had surgery to remove that lesion. Mr. Sherman is probably absolutely right. That probably saved her life. But this surgery was no small matter. We're going to hear about that. The surgery resulted in her losing part of the bone in her pelvis. She lost part of her sciatic nerve, which is the nerve that innervates the right leg. She had surgical screws implanted in her pelvis to stabilize the sacroiliac joint. And it left her with a large scar. Following the surgery, she had a number of physical deficits, significant physical deficits. For a while, she was incontinent of her bowel and bladder. She had what the medical professionals call ABL deficits. ABL simply means activities of daily life, the kinds of things we all do in the course of the day to take care of ourselves, showering, toileting, cooking. She couldn't do those things. She had a right foot drop, flaccid right foot. Couldn't hold it up at the proper angle because part of her sciatic nerve was gone. In fact, you're going to hear evidence from Dr. Andrews, the surgeon who repaired the fracture after she fell, that in her case, her right foot drop was worse than the normal foot. In short, she had an extremely weak right leg. She had serious problems walking, and she had no endurance. And last but not least, she was in a lot of pain. In September 2008, she comes home from Texas to Hobart. She didn't bear any weight on that right leg at that time. She's not weight bearing. She has a rolling walker and a wheelchair with a platform to put her leg on to get around. She has to get a special bench for the tub to bathe. She has to have bars installed in the bathroom. She has to have a bedside commode. She has to be taken care of by her son's girlfriend. Drives her to doctor's appointments, drives her to therapy, does meal preparation for her, because she can't do these things herself. MD Anderson sets her home with a script for physical therapy to start rehabbing that right leg. And so in October of 2008, she goes to the St. Mary Medical Center, she has an evaluation, and she starts therapy. That's a year before this accident happened, 1 full year. So what happens in that year? Within the year, she does improve. She progresses from a wheelchair to a walker to a cane. Her strength improves. She does have better endurance. But at the end of that year, just before she fell, she is still only able to walk using a cane. They are only then beginning to try to have her walk a few independent steps without an assistive device. And at the same point in time, her therapists are planning her discharge from therapy. They're planning it because she's plateaued, because she is not going to get substantially better. And that is the context in which Mrs. Harris was out on the track on October 1, 2009, walking laps by herself. So what happened to her on that day? Well, as you've heard Mr. Sherman say, he's going to do his best to convince you the clinic was unreasonably dangerous. It was dangerous because there was a rug there at all, and that it was dangerous because the corner of the rug was flipped up. I'm showing you on the screen there a picture that will be into evidence shortly that shows the rug and the area where it was sitting and the portion of the walking track. You're going to hear Mrs. Harris tell you that she was using the quad cane in her left hand, and her left hand walking, and that it caught the corner of that rug closest to her left hand, and that's what caused her to fall. That's going to be her explanation. You're going to hear her tell you she was out there walking by herself because the therapist told her to do that. In fact, there's nobody besides Mrs. Harris who witnessed this fall. There's nobody that's going to be able to confirm that any corner on that rug was flipped up as she claims. Now, the problem with all of this is that when you listen to this story in the context of all the evidence you're going to hear, it makes absolutely no sense. You're going to see therapy records in this case that show in the year before she fell, Mrs. Harris had 93 therapy treatments, 93, through which she would have gone through those doors to go in and out of her therapy treatments every time. She would have passed over that rug, either in a wheelchair or walker and a cane, coming in and going out. That adds up to 186 times that she went over that rug without falling, including one time just minutes before this accident happened. You're going to hear that she has a history of falls. She fell several times during the course of therapy at home. You're going to hear that after her fracture healed, she moved down to Mississippi and she fell there 2 or 3 times. I expect Mrs. Harris to tell you that during the course of her therapy, she constantly complained to her therapist about that rug. She thought it was dangerous. She thought it was a hazard for her. And yet, she's going to tell you she was voluntarily walking on that track the time she fell and over that rug. You're going to hear that despite her concerns about that rug, she only saw the corner flipped up on it basically a split second before she put her cane down on it and she says got caught on the corner. That's the first time she noticed anything wrong with her. You're going to hear that before this accident happened, she had been told, wait for your therapist. Go in and wait for your therapist. You're going to hear that the defendant said nobody ever told her to go out on the track and start walking laps by herself. They never told her. And just a week before this accident happened, she was evaluated by Mr. Brownbaugh, who was making the decision at that point in time that she plateaued. She wasn't going to get much better, and that they were going to wean her from therapy in favor of a program of home exercise, and that she should have a family member come in henceforth and be a part of those therapy treatments. And yet, on the day of this fall, she was out there walking by herself. You're going to hear that this walking track, this isn't a gymnasium like LA Fitness or the YMCA or Gators. They still have Gators out there somewhere. This isn't like that. People aren't coming in there walking laps to walk off a few extra pounds or to get their exercise. It's used in very specific instances to do very specific things. And finally, let me tell you something you're not going to hear. During this case, you're not going to hear any evidence that on the day of this accident, anybody at the clinic knew that there was a corner of a rug flipped up that presented a hazard. Mrs. Harris is going to give you what I think is a pretty detailed description of how her fall occurred. I want you to listen to it carefully when it happens, because I think what it shows is that her description is totally inconsistent with the claim that she tripped and fell over the rug, and it's totally inconsistent with the direction she fell and how she landed. It doesn't add up. Now, the judge started to read a very long list of witnesses this morning. I assure you, you're not going to sit through all those people. We're expecting probably 5 to 7 witnesses in this case, including the deposition. You're going to hear from the physical therapist and the 2 physical therapy assistants who last treated Mrs. Harris over the course of several months leading up to the fall. You're going to hear from somebody named Tracy Golan. Tracy Golan was a physical therapy assistant who no longer works at the St. Harris. She treated Mrs. Harris for a period of time in the summer for several months. And she's going to come in and testify live. She's going to tell you, I never told her to do that. You're going to hear from Amber Kimbrough, who was a physical therapy assistant, who was the son of Mrs. Harris at the time she fell. She's going to be here live to testify too. She's going to tell you, I never told her to do that. You're going to hear from Sashi Brahma by way of deposition, He's the guy that just a week before the accident told her, "We're weaning you from therapy, have a family member start coming in for these treatments to see what's going on." Defense is going to bring in a therapist from Bloomington, Indiana by the name of Boston Hefner. Now, the medical malpractice part of this case, by law, had to go through a medical review panel, which included, among other people, Mr. Hefner. He's going to talk about what their opinion is. He's going to talk to you about how they reached it. But one thing he's going to tell you is that in his facility in Bloomington, Indiana, they have rooms just like this in the treatment room. And he's going to tell you why those rooms are there and why they're necessary. And the defense is also going to bring in its own independent physical therapy expert, a guy by the name of Michael Manning. He's a doctor of physical therapy. He practices at the University of Chicago. He not only treats patients, but he teaches clinical therapy students. And he has been a manager of clinical therapy facilities. He's going to tell you several things, not the least of which is going to tell you that having that kind of drug in the treatment environment is not unsafe to the patients. He's going to tell you that Mrs. Harris' leg was so weak and so impaired from the cancer surgery that it alone put her at risk. And she was going to have trouble with this leg going forward in life. And he's going to tell you that based upon her description of how she felt, it's his opinion that she fell because that leg fatigue collapsed underneath. Finally, you're going to hear deposition testimony from Dr. Andrews, the surgeon who repaired the fracture after this accident. He's going to tell you that she had no complications in the surgery, that she had a good outcome, that he expected her to recover and heal to the point, her baseline stage of health before she fell and had a fracture. And he doesn't have any reason to believe that she hasn't done that. He's going to tell you that she's not using a walker today on account of anything that he's told. The defense isn't going to try to minimize the injury here. The injury is what the injury is. It's serious enough. We're not going to try to diminish that in any way. But it is what it is. And finally, Dr. Andrews is going to tell you that he's got that rug sitting in the doorway in his office, where patients with gait deficits and lower extremity problems go in and out all the time. Ladies and gentlemen, I don't think the evidence in this case is going to support the conclusion that Mrs. Harris tripped on this rug. I simply just don't think it does. But whether she fell on this rug or whether she fell for some other reason, the evidence is going to show that this accident wouldn't happen if she had simply done what she was told to do, which is go in and wait for your therapist and bring somebody for following therapy. If she had done that, we wouldn't be sitting here today. There'd be no lawsuit. And so at the conclusion of the evidence, I expect to come back here and ask you to return the verdict to the hospital on all counts. Thank you.
All right, ladies and gentlemen, at this time, we've reached the noon recess. What I will do is we will try to adjourn by 4:30 every day. We'll start in the morning at 9. Lunch will be provided to you. The bears will escort you to the cafeteria. Lunch will be provided to you. We will reconvene at 1 o'clock. Once again, you're not to discuss a case with anyone other than yourselves, and only when you're all present in the jury room.